Okay, good morning, guys. So today we'll be finished up with module 8. And guys, this is going to be the end of our syllabus. So I'm expecting whoever listen to this will do past questions and ask questions. So, okay, let us begin. Okay, so we ended there where we have to explain these three, these four primary reasons. Okay, so let us start with termination by performance. What does it mean of termination by performance? Okay, so when all of the provisions of the contract have been satisfied, the contract will be terminated on its own without further action being required. So, termination by performance, it's whereby the contract ends on its own. It doesn't need further action, so it ends on its own. This indicates that all of the requirements outlined in the agreement must have been met in full. There is a possibility that the contract will allow for partial performance in exchange for a lesser payment. If one party has made it impossible for other to fulfill their commitments in full, it is possible that it is still feasible to argue that the contract has been satisfied, even though the requirements have not been entirely met. So that is basically termination by performance. And then number B is termination as a result of mutual consent. Okay, let's hear what does that mean of termination as a result of mutual consent. Both parties may find it advantageous to end the agreement. A change to a contract should be made to make sure neither party is left vulnerable to a future claim of violation of the contract. The contract must contain some form of obligation of payment between the parties in order for it to be enforceable. Alternatively, a settlement can be signed by all parties that releases them from their contractual duties. Okay, an agreement may also contain clauses that allow for argument-based termination, in which case those provisions may be invoked. The contract must be appropriately cancelled in order to prevent any potential claims in future. Okay, so basically termination is a result of mutual consent, which whereby both parties find it advantageous to end the agreement. So it's whereby the both parties agreed on each other that they must end the agreement. Okay, so let's move on to termination of contract due to frustration. So a termination of contract due to frustration is whereby a contract may be cancelled out the contract may be terminated if there has been a material breach, in which case the violation must be serious enough. To determine whether a violation was significant, the court will consider whether the term in question was essential to a contract's performance. If an immediate term is violated, the contract may only be terminated in terminated by breach. It's whereby a contract may be terminated if there has been a material breach, in which case the valuation must be serious enough to determine whether a valuation was significant. The courts will consider whether the term in question was essential to the contract settlement. If an immediate term is violated, the contract may only be terminated if the valuation frustrates the agreement's commercial purpose or deprives the other party of practically all of its benefits. If this is the case, the agreement may be terminated and damage may be sought. Okay, so that is when we terminate the contract by breaching. Okay, even if they wouldn't be major breaches separately, several minor variations can add up to a serious violation. Okay, so let's move on to 8.1.8, arbitration. A private contractual method of resolving disputes in arbitration. It stipulates that disputes will be settled by arbitrator or arbitration panel chosen by the disputing parties. Conflicts are settled using appropriate legal proceedings, documents, and material facts. An arbitrator is selected to oversee the arbitration procedure according to any applicable contractual clauses and the legal regulations framework used by courts. Only a small number of cases are eligible for appeal and prevail side in favor given the legal fees. So we have advantages and disadvantages of arbitration. Okay, so the advantages is it is private, although not necessarily confidential. There is no public information of any proceedings. Speed, although this greatly depends on how the arbitration managed the dispute. The party may choose an arbitrator who has the necessary subject matter competence. The arbitrator decision may be made enforceable by a court order. And then those are advantages. And then when you look at disadvantages, the cost of the arbitrator and the venue must be borne by the parties. Arbitration can occasionally be just another version of the judicial system. Thus, the benefits of information and speed are lost. Limited power of force or consequence if a person disobeys an arbitrator's order, which can drag out the procedure considerably. Okay, so guys, those are disadvantages and advantages and disadvantages. Please go through them. Then we look at insurances. An insurance contract is a legal agreement whereby one party and insurer accept a feasible amount of insurance risk from another, the policyholder, in exchange. The policy number in exchange of change for insurance promises to pay the policy holder compensation in the event that a specific and unforeseen future event known as insured event negatively impacts the policyholder. Yes, so guys, as we all know and understand, the insurance would say on how it operates. So, also in the companies or in industries, there is insurance for a company. So, it is very important to make an agreement with the insurers so that you make sure that everything is under control. We have some of the specific clause of contract conditions, which are loss or damage during transportation, damage of surrounding properties, cost due to the removal of debris after an accident, damage during testing and commission, incident during work away. So there are so many guys, you can go through them. So those are specific clause of contract. Then let us look at 4 main insurance that are required in construction contracts, which is a latent defense insurance, all risk insurance, and public liability, professional indemnity insurance. So those are 4 insurance that are required in a construction contract. Okay, so for A, all risk insurance contract says all risk insurance covers significant losses to the work being built and has an option to provide coverage for injury and property losses to third parties. Latent defect insurance, if an inherent flaw in the construction design, execution, or material cause physically loss or damage to building structure or waterproofing envelope. Latent defects in insurance offer protection. And we have public liability insurance. So public liability insurance is a type of commercial insurance that protects your company from claims made by members of the public sustain injury, fatalities, and property losses as a result of the operation. So that is public liability insurance. Then we have professional indemnity insurance. Okay, for companies that offer specialized or professional service, professional indemnity is a crucial type of protection. It is made to address complaints made against your company for damages sustained as a consequence of real or claim irresponsible acts or omissions during the delivery of your expert assistance or guidance. Okay, so there is professional indemnity insurance. Okay, there's an activity there. It helps you understand better the modules. Then now let us look at Unit 8.2, the labor laws. Okay, laws pertaining to labor are those that regulate the connection that exists between employers and employees. So as we all know that there is a law that must act between employer and employee. Okay, the government is responsible for drafting this law The primary objectives of legislation pertaining the labor law is provide protection for the rights of the workers when they are employed. There are about 11 labor laws in South Africa. So, guys, it is important to know your labor laws. So, this textbook is so helpful. So, they explain or they give you the 11 labor laws, which are the labor relations, the basic condition of employment, the national minimum wage, employment equity, broad-based Black Economic Act, skills developed, Act number, skills developed levies, Public Holiday Act, the Constitution of the Republic of South Africa, compensation for occupation injury and disease, occupational health and safety. So those are 11 labor laws. Read them and understand these guys. They will help you in future. Okay, so now let us move to 8.2.1, whereby organization rights. Organizational rights. In a workplace, a registered labor union has the ability to exercise certain rights known as organizational rights. The goal of granting union the free to organize and represent employees at their places of employment is to fulfill the purpose of organization rights. Every worker in South Africa is afforded the rights as outlined in the Republic of South Africa's Constitution to organize, join, and take part in the activities of trade union of their choosing. So, guys, if you are an employee, you have a right of joining these parties of organization rights, so that you will know your rights as an employee. So it is important to know about this organization. Okay, we have 5 organizational rights recognized by Labor Relations Act, which is trade union access to the workplace. Trade union to access in the workplace is whereby it is permissible for an official to assess the employer's facility in order to recruit membership and serve the interests of those members. So, trade union is whereby it helps you if you have complaints that work relevant, then it helps you. They help you. They give you advices, decisions to take, labor law to go to, all of those things. So, guys, it is important to understand your labor laws and these unions. Then for B, deductions of trade union descriptions or levies. The union may demand an employer to make authorized deductions of union subscription from the wages of employees and then hand those funds over the trade union. This may be required of the employer by the union. This is sometimes sometimes referred to as union stock orders. So guys, whenever you join these parties, just know that you will pay for them. So the deductions are made into your money, your salary. So if you join, they take up to your salary so that they're able to pay this union. And then we have trade union representative. Members of registered trade union have the ability to vote for and elect representatives at their places and their place of employment. Those who are elected have the authority to represent employees in prevent and disciplinary hearing, monitor employee compliance with employment law and collective agreements, and report any violation. Take reasonable time off with pay to perform or to be trained in their functions, and take reasonable time off with pay to perform or to train in their functions. So those are trade union representatives. Okay, and then we go through to leave for trade union activities. There is also a leave for trade union activities. Okay, an employee who holds an official within the union has the legal right to take reasonable amount of time off during their regulation working hours in order to fulfill the responsibilities associated with holding that position. So, the employee has the legal right to take leave when they want to, or to take time off when they want to work hours on this union. Disclosure of information. This is an illustration of what was referred to earlier as a majority right. In order for a union to be able to properly participate with the employer in discussion or collective bargaining, the union may request that the company reveal any all participant information. In closed shop agreement. A closed shop agreement is a type of collective bargain agreement that mandates that 9 union workers must sign up for union representatives. So there is a closed shop agreement. Then we have two constitution that concludes of closed shop agreement, which is trade union, an employer, or an employer organization. Okay. So a closed shop agreement is only legal binding under the following condition. It was by votes of at least 2/3 of parties of employees. Prior membership in a labor union is not necessary for workers to be hired by an organization. Duties and levy payments are collected solely for purpose of promoting or protecting the social economic interest of work. No payment for members due to will ever be made by a political party, nor will any political figure in any standing position gain financial support from membership. Okay. Then we have when a trade union is included in a closed agreement, it is prohibited for the union to refuse any employee membership, and it is also prohibited from expelling a member of the union. So we have the conditions of organization or they need members altogether, which are the refusal must be a part of constitution of trade union. It must be fair to refuse or dismiss a member, and the reason for the denial of dismissal must be that member undermine the rights of trade union. Then there is a collective agreement. A collective agreement is a written contract that was negotiated for employees by one or more trade unions through the process of collective bargaining. So guys, the collective agreement, it is a contract that is written and negotiated for employees by one or more trade unions. Okay, there are three essential components that set the collective agreement apart from any other type of agreement that may be reached between employees and employer. So we have a collective agreement needs to be written down in order to be part to a collective agreement. A trade union needs to be officially registered. In order to be considered a collective agreement, the agreement must define terms and conditions of employment or any other topic of mutual interest between a trade union and employer or employees organization. Then we have bargaining council. Bargaining council are responsible for negotiation, collective agreement, mediating labor disputes, setting up a variety of programs, and providing feedback of labor policies and legislation. Bargaining council membership is open to application from both labor unions and employer organizations. Members of the bargaining council may include the following parties. So it's trade union, group representative, virus, employer, the government of state. Then we have a bargaining council. Council is responsible for the following functions. So these are the functions of bargaining council, which is coming to an agreement over a collective bargaining agreement, enforcing the collective bargaining agreement to prevent and settle labor disputes in order to carry out the functions of the contract. So those are the all functions of the bargaining council. Let's go through them. Then we have statutory council. Okay. The Statutory Council is an organization formed under the Labor Relations Act 1995 in an industry sector where no bargaining council exists. The primary responsibility of council is to act as a conflict resolution body for any parties that come within the registered remit of the council. Disputes that involve issues like as termination, unfair labor practice, and other topics of shared interest may be brought before the council for resolution. So we have examples of roles that statutory council play. Go through those examples, guys. Then we have dismissal procedure. A person is said to be dismissed when their employer decides to end their employment despite the employee's desire to continue working there. The grounds for terminating an employee's employment might range from an economic slump to concerns linked to employees' performance on the job. By terminating an employee's employment, employers should at all times adhere to appropriate protocols. Employers are required to retain records for each employee that include the infraction committed by the employer. So the disciplinary action that was taken, the reason behind the action that was taken. So this is the dismissal procedures. There are main steps termination process. So we have 5 steps. Step number 1. Is to conduct an investigation into relevant issues. Step number 2, put the employee on the notice about the problem in writing. Hold a meeting or hearing with employee to discuss possible disciplinary actions. Write the letter to employee informing them of the decision. Provide the employee with the opportunity to file the appeal. So, okay, they are explaining these examples in detail. They are explaining these steps in detail. So, guys, you can go through them. Just gonna jump to dismissal for misconduct. Okay, David here. Dismissal for misconduct. It is strongly recommended that employers establish transparent guidelines for employee behavior that are communicated to each and every employee. It's possible that some standards are so well known or so evident that it's reasonable to assume that everyone is aware of them. For instance, it's not appropriate to avoid violence at work. So dismissal for misconduct will only be fair if the worker broke a rule of conduct in the workplace. The rule was reasonable and necessary. The work knew of the rule or should have known of the rule. Okay, so those are dismissal for misconduct. Okay. Then we also have the dismissal of incapacity will only be fair if the employer has given the worker proper training, instruction, evaluation, guidance, and advice. So, guys, these are dismissal for incapacity. So, before the employer must dismiss you, he or she must be done the following to you, so that if she or she really trained you properly, then you have to you can fight this if it was unfair dismissal. So guys, go through all those dismissal for incapacity. Then we have operational requirements. Operational requirements of an employer's business. When the employer intends to fire one or more of their employees, this situation arises. It is permissible for an employer to lay off workers due to operational requirements if the operational requirements are based on the firm's economic, technological, structural, or similar needs. Dismissal for operational requirements will only be fair if whoever a collective agreement says must be consulted is consulted, or if one exists, the worker forum, or if one exists, none exists, the union, or if none exists, the worker themselves. So the employer must issue a written notice giving reason for retrenchment. Alternative considered, including redeployment, number of workers to be retrenched, how it will be decided which workers to retrench, when the dismissal will take place, severance pay, what other help the employer will give to the workers who will be retrenched, possibilities of future re-employment for these workers. Okay, so those are the reasons and notice of the return to employer. Then we look at unfair dismissal. Even if corresponds with any notice time that is stipulated in an employment contract, this governs employment and dismissal as nevertheless considered as unfair if it is not carried out for fair reason in line with fair method. Okay, so the employee is fired for any of the following reasons. The dismissal will be deemed automatically unfair by the court. Exercising any of the rights granted by LRA or engaging the procedures in accordance with an act. Participating in lawful union activities, taking part in illegal strike or other industry action or protest action. Refuse to do work for someone who was on strike, being pregnant or for any reason related to pregnant, being pregnant, okay, refuse to accept the change in working conditions, reasons that are due to arbitrary discrimination. So those are the examples of unfair dismissal. Okay, so let us look at the dispute procedure. Okay, the process of resolving this disagreement or conflict between parties is referred to as dispute resolution or dispute settlement. Although conflicts are typically longer and more in depth than disputes, the terms dispute resolutions and conflict resolutions are frequently used interchangeable. Okay, so we have three ways to deal with disputes in a workplace, which are negotiation, mediation, and arbitration. Then they explain those three ways each by each. So please guys go through that. Then we move to strikes and procedures. The work stoppage is referred to as strike action, labor structure, or simple strike, and it is brought about when a significant number of workers refuses to perform their job. Strikes are typically the result of employee complaints about their working conditions. The Constitution of South Africa states that every worker has the right to strike, which is a clear indication that the freedom to strike is clearly protected in this country. So guys, if you as workers see that you don't get the right service, you don't get your needs in a company, you have the right to strike. So the type of actions that should be performed will be determined by the purpose of either the employer or the employees. Okay, the purpose of the strike is to address an employee grievance or find a solution to any issue that is of mutual interest to both employees and employers. A second strike is a strike held in support of another strike referred to as a primary strike. The aim of the secondary strike is to put pressure on the original employer to give it to demand that the strike employees are making the primary employer. Protesting action is undertaken to promote or defend the socio-economic interest of workers. So those are the purpose or type of actions that should be performed with determined by the purpose of either employer or employee. And, okay. A strike must adhere to these three principles for it considered a strike opposed to an act of misconduct. So we have these three principles, which is there must be a refusal of work. The refusal must be by person employed by the same or different employers. The refusal must be for the purpose of redressing a grievance or resolving a disagreement in respect to any topic that is of mutual interest of an employer and employee. Then we have activity guides in the summary of this module. Please go through those activities. Okay, so this is the end of our syllabus. So tomorrow I will try to download past papers so that I will share them with you guys. Oh, by the way, there are past papers on Moodle, so you can use this textbook and the past papers on Moodle and study for your test 2 and also for your final exam. So thank you so much, guys, for your time. I hope these videos are very helpful, will be very helpful to you. So thank you. Bye.
Hello,